In order to constitute valid consent absolving the defendant from criminal liability, the consent must be positive and genuine. Consent must be positive. It is not sufficient that the victim doesn't object or say no. Consent differs from submission. In R.V. Oleg Bodger, the defendant was liable for rape despite the fact the victim did not say no and took down her own trousers. This was because she was acting out of fear. The consent must be genuine. This consists of two requirements. 1. The person giving consent must comprehend the nature of the act to which they are consenting. 2. The consent must not be vitiated by fraud. Where there is no statutory prohibition from children giving consent, they may nevertheless lack capacity to give consent if they are not capable of comprehending the nature of the act. The Gillick Competence Test and Fraser Guidelines from Gillick v. West Norfolk and Wisbeck AHA are used to establish whether a particular child is capable of giving consent for a particular action. Children may lack the ability to comprehend the nature of the act. In Burrell v. Harmer, the defendant tattooed two boys aged 12 and 13. The boys had consented to the tattoo. It was held that the boys' consent was ineffective since they were unable to comprehend the nature of the act. A person may lack the mental capacity to appreciate the nature of what they are consenting to. There is a presumption of capacity under the Mental Capacity Act 2005. However, a person may be found to lack capacity if at the material time they are unable to make a decision in relation to the matter because of a temporary or permanent impairment or a disturbance in the functioning of the mind or brain. Fraud will only vitiate consent where it relates to either 1. The identity of the person or 2. The nature and quality of the act. Fraud as to the identity of the person will vitiate consent. In R.V. Elbeke, in the context of rape, it was held that the rule on impersonation of a husband included a boyfriend where it was done to procure consent to sexual intercourse. The fraud must be as to the identity of the person, not their attributes. In R.V. Richardson, the fraud did not vitiate consent where the defendant was struck off from practicing. The patients had consented to dental treatment on the basis that she had the right to practice. However, this did not relate to her identity and therefore she was not liable for ABH. Fraud as to qualifications may relate to the nature and quality of the act and therefore vitiate consent. In R.V. Tabassum, the defendant examined women's breasts. The women consented as they believed he was medically qualified. Originally, a restrictive approach was taken in relation to fraud as to the nature and quality of the act. In R.V. Clarence, 1889, the court held the wife had consented to sexual intercourse. It did not matter that she might not have consented, had she been aware that he had gonorrhea. This was departed from in the case of R.V. Decker, where the defendant knowingly infected two women with HIV. They had consented to having unprotected sexual intercourse but were unaware of the risk. It was held that the decision in R.V. Clarence did not survive the decision in R.V. Brown, where it was held that a person could not consent to harm resulting from sexual conduct. The courts would only recognize that fraud vitiated consent in extreme cases. In R.V. Flattery, 1877, the defendant was liable where the victim, who had learning disabilities, consented to sexual intercourse believing it to be a surgical procedure, and in R.V. Williams, a singing coach was liable for rape where he told a pupil that he was performing an act to open her airways to improve her singing voice. In Lineker, 1995, the fraud did not vitiate consent where a prostitute consented to sexual intercourse on the understanding that it would be paid for. The Sexual Offences Act 2003 provides that for the purposes of the Act, a person consents if they agree by choice, and has the freedom and capacity to make that choice. In R.V. Jeter, 2007, it was held there was no free choice where the victim consented to sexual intercourse with her boyfriend as a result of receiving texts from him pretending to be a policeman. In summary, to be effective, consent must be positive, genuine and not vitiated by fraud, and the person giving consent must understand the nature of the act to which they are consenting and have the capacity to do so. This video is part of a series of videos on law from www.e-lawresources.co.uk. Please subscribe to our YouTube channel www.youtube.com/@e-lawresources. It's free to do so and will help us to keep providing these videos. Check out our website, which provides lecture outlines and case summaries. See also www.e-lawrevision.org.uk for revision games and quizzes. Thanks for watching.